Welcome to Litigation Nation. I'm your host, Danessa Watkins, here with my co-host, Jack Sanker. As a reminder, this is the podcast where we bring you the new, exciting legal news from across the country. Jack, what do you have teed up for us today?
There's a Second Circuit ruling that could really upend the model that many local libraries use and could make it nearly impossible for libraries to continue lending electronic books. We're going to get into that.
Interesting. All right, all that and more. Here's what you need to know.
So I first came across this story in the MIT Technology Review, which was a short article, but the further you dive into this, the bigger a deal it becomes. I saw some people kind of chatting about this on Twitter and everything else. And I'm going to be relying on a series of articles that chronicle the progress of the actual lawsuit that were published on a website called arstechnica.com, as well as the MIT Technology Review. I'll do my best to keep that straight when I'm talking to you all here. But I'll start for the MIT piece, which was authored by Chris Lewis, quote, "A ruling from the U.S. Second Circuit against the Internet Archive and in favor of publisher Hachette has just thrown that promise of equality into doubt by limiting libraries' access to digital lending. To understand why this is so important for the future of libraries, you first have to understand the dire state of library ebook lending. Libraries have traditionally operated on a basic premise. Once they publish a book, they can lend it out to patrons as much or as little as they like. Library copies often come from publishers, but they can also come from donations, used book sales, or other libraries. However the library obtains the book, once the library legally owns it, it is theirs to lend as they see fit. Not so for digital books. To make licensed ebooks available to patrons, libraries have to pay publishers multiple times over. First, they must subscribe for a fee to aggregator platforms such as Overdrive. Aggregators like streaming services such as HBO's Max have total control over adding or removing content from their catalog. Content can be removed at any time for any reason without input from your local library. The decision happens not at the community level, but at the corporate one, thousands of miles away from the patrons affected. The libraries must purchase each individual copy of each individual title that they want to offer as an ebook. These ebook copies are not only priced at a steep markup, up to 300% over consumer retail, but are also time limited and loan limited, meaning the files self-destruct after a certain number of loans. The library then needs to repurchase the same book at a new price in order to keep it in stock," unquote. So that's a lot of information to dump on everyone at the start, but what we're going to be talking about today, and that kind of sets the scene for this big decision from the U.S. Second Circuit, which granted a permanent injunction against a company called Internet Archive. Internet Archive, as we'll get into a bit, is a website which often partners with different libraries to digitize physical copies of books that the libraries have and create basically a digital copy or an ebook based on a physical copy, and then to lend it out. We'll get into that lending process. It's fascinating the way that they actually do the controlled digital lending in a little bit, but you should know, I'll tell you how the story ends at the start here, which is there's a permanent injunction against this process, and many, many, many libraries and folks that like to use the libraries are going to be affected by this. So I mentioned this a moment ago, the loan limited aspect of how ebooks are obtained by libraries, and it's actually very interesting. The logic is that ebooks, or at least this is what the publishers will say, ebooks are limited in the amount of times you can loan it out because it's kind of meant to mimic the process of how physical books would wear out over time. So if you lend out a book, 500 times, it's going to fall apart. And that's what the publishers will say is why they limit the amount of times an ebook could be lent out. They're trying to mimic that same physical deterioration. And then once it hits that limit, the book, you have to pay another licensing fee or something like that. Of course, local libraries can and do get a lot of donations from other people. That's where a lot of their books actually come from. Whereas, ebooks aren't donated. So that analysis really isn't one for one as to, how a library actually functions. I'm going to go back to the MIT piece, back to Chris Lewis here. Quote, "Some libraries have turned to another solution, controlled digital lending, or CDL, a process by which a library scans the physical books it already has into its collection, makes secure digital copies, and then lends them out on a 1-to-1 owned-to-loaned ratio. The Internet Archive was an early pioneer of this technique." I'll pause there for a moment. What they would do is physically scan an actual book, like a paper book that none of us read anymore, and then lend out the digitized copy for folks to read on their Kindle or whatever it is.
So you're, in some ways, though, you're relying on the physical manpower of the library to do that. So that costs money.
Yeah.
And then, obviously, the quality is probably not going to be as good as, if you're getting it directly from the source.
That's a good point. But, like, at the outset, this is someone making a copy of copyrighted work, right?
Right.
So if you're an attorney, or if you've been around, or if you're in the publishing industry, or if you just know enough about copyright, this should be raising red flags for you already. Going back to the piece, quote, when a digital copy is loaned, the physical copy is sequestered from borrowing. When the physical copy is checked out, the digital copy becomes unavailable. The benefits to libraries are obvious. Delicate books can be circulated without fear of damage. Volumes can be moved off-site for facilities work without interrupting patron access. And older and endangered works become searchable and get a second chance at life. Library patrons who fund their local libraries' purchases with their tax dollars also benefit from the ability to freely access the books. So the model here is that they have a physical copy, scan and digitize it, loan it out ideally without being accused of pirating the physical copy. And from the library's perspective here, so long as only one copy is being loaned out, right? So the physical copy's out, the digital copy is unavailable. Digital copy's out, the physical copy, doesn't get loaned, right? So there's never more than 2 copies going out. From their perspective, and as I understand some of the arguments they made, they're not quote unquote copying it then, right? I don't know about that, but
this was a wide practice. This is what libraries were doing across the country.
Yeah, we'll get into that. Something like 60 or so libraries had partnered with the Open Library Project to do this, and this process I think was I don't know how commonplace it was, but it was happening enough at libraries all over the country. So I wouldn't say that every library is doing this, but from what I could gather, it was pretty common.
Interesting. Okay.
Yeah. So the Open Library Project, which partners with libraries to scan print books of the collection and offer them as lendable ebooks. Basically, a bunch of book publishers sued them to stop them from this controlled digital lending project on copyright infringement grounds, really just alleging the act of copying and lending the book itself is an act of piracy. No different than, downloading a song to Napster. God, no one's going to know that reference now. No one downloads music at all. You know what I mean. Okay. The plaintiffs in this case were some names you might know: Hatchet Book Group, HarperCollins, John Wiley and Sons, and Penguin's Random House. Quoting from the complaint, which was filed way back in June of 2020, and by the way, that gives all of you, non-litigators a sense of how slow these cases can move. This case is over 4 years old at this point. Defendant IA, and that's Internet Archive, by the way, is engaged in willful mass copyright infringement without any license or any payment to authors or publishers. IA scans print books, uploads those illegally scanned books to its servers, and distributes verbatim digital copies of the books in whole via public-facing websites. With just a few clicks, any internet-connected user can download a complete digital copy of in-copyright books from the defendant. The scale of IA's scheme is astonishing. At its open library, located at openlibrary.org and archive.org, IA currently distributes scanned digital copies of over 1.3 million books, and its stated goal is to do so for millions more, essentially distributing free digital copies of every book ever written. Despite the Open Library moniker, IA's actions grossly exceed legitimate library services, do violate the Copyright Act, and constitute willful digital piracy on an industrial scale. Consistent with the deplorable nature of piracy, IA's infringement is intentional and systematic. It produces mirror image copies of millions of unaltered in-copyright works for which it has no rights and distributes them entirely for purposes to the public for free, including voluminous numbers of books that are currently commercially available, unquote. So, as I understand it, the Internet Archive argued that the copying of books in the way that we've talked about here constituted fair use because they were, I suppose, transforming the nature of the books by copying them from physical print to digital. That doesn't sound too convincing to me.
Well, before we get into the fair use arguments, I'm just kind of curious because what you described in the beginning, as opposed to what was alleged in the complaint, seemed to be at odds, which is sometimes the way it goes, and you find out in discovery that what's been alleged isn't actually the real facts. But because it seems like they're alleging that these libraries are scanning in these books and distributing them widely. What you described in the beginning, though, is that it seemed pretty systematic, that if there was one copy available electronically that could be used by one person at a time.
Right.
But if somebody had the physical book, then that wasn't even available to disperse.
Yeah, I mean, the allegations collapse those distinctions. I mean, these are allegations, right? These are what the publishers are alleging. It doesn't mean it's the case.
Right.
So they're not making that distinction. What they're saying is you're copying the books and putting them out for free online.
Yeah,
right?
no, they're simplifying.
And what the libraries are saying is, no, we're only making one copy.
Yeah,
And we're only doing one little piracy instead of. The point is it copyright infringement or not? Regardless of how bad of copyright infringement you're doing.
Mm-hmm.
This whole concept of fair use, I think it's worth taking a beat to talk about that. Danessa, if you could help me.
Yeah, I got you. So the fair use doctrine, it's essentially a legal exemption that will allow a limited use of copyrighted material without the copyright owner's permission. So it's really like a balance between the interests of those holders of the copyright and the public's interest in creative work. The doctrine kind of looks at 4 different factors, the first being the purpose and the character of the use. So is the use of the copyrighted material for commercial purposes, or is it not-for-profit or educational purposes, which would tend to lean more towards fair use?
Right. So for teaching in libraries, for example.
Exactly. A second factor is social benefit. So whether the benefit of having that copyrighted material used in a limited fashion would exceed the loss to the copyright holder. Here, again, it would seem that would weigh in favor of the library. Mm-hmm. Third is the market impact. So whether that limited use will hurt the original work's market, such as displacing sales. Mm-hmm. The way they alleged it in the complaint, that makes it seem like, right. Of course, yes.
You're displacing millions of copies, or millions of sales of copies versus just the one.
Right. Yeah. So that would just come down to the factual inquiry of what's actually happening at the libraries. And then the fourth factor is widespread harm. So whether allowing this limited use could actually cause substantial harm if it became widespread. I mean, that factor, I think, is always going to weigh in favor of the copyright holder because...
Yeah, that seems kind of baked in there.
Yeah. So it's definitely a case-by-case basis, depends on the facts of each circumstance. Just some kind of broad examples of fair use are criticism, scholarship, news reporting, and parody. So you can pick out sentences of a book, for example, and make fun of it or criticize the writing or use it in a classroom setting and, teach your class about it verbatim. There's really no specific number of how many copies or how many words can be reproduced without permission. Again, it's case by case. But generally, the more material that you're copying from the original, the less likely it's going to be considered fair use.
I have a good parody example.
Yeah.
Did anyone ever watch Nathan For You by any chance?
No.
There's a fantastic episode where he pitches a business idea, which is just a 1-for-1 knockoff of Starbucks. Its exact branding of Starbucks, its identical store setup, except he calls it Dumb Starbucks. So you would walk in and it's welcome to Dumb Starbucks, and then he, according to the bit on the show, was circumventing intellectual property laws by parodying Starbucks just by making a copy but calling it Dumb Starbucks, and referred to the store as an art gallery and not a chain coffee. Mm-hmm. And I do believe Starbucks sued, and I think that they settled it, but I would love to read a law review article on whether that actually was parody or not.
Yeah, it might be too close.
I have a Dumb Starbucks mug at home. Which is
big fan.
Maybe copyright infringement.
The only other thing I could say is the courts will also look at whether you could get your point across by copying less of the work than what you're copying. So you know, maybe you only need a sentence or two, and you didn't need the 5 paragraphs or the 6 chapters. But here, I mean, they're taking the full book. So
right, like, and this is enforced all over the place in different ways. I know, like, for example, if you want to upload a YouTube video, maybe you're a film critic, right, and you want to upload bits of a film to talk about and create a YouTube video. YouTube itself enforces their own policy of a certain amount of time that you can play a clip for. I don't know if that's based on a prior decision. I bet it is. I bet there is a decision which says uploading a clip longer than, 30 seconds or 3 minutes?
3 seconds.
Oh, 3 seconds. Oh, boy.
Like music, you get 3 seconds.
Oh, you get 3 seconds. Okay. My producer's telling me it's 3 seconds. But if you upload a clip longer than 3 seconds, you now have exceeded, the amount that you really need to make your point.
Right.
Otherwise, you could just put the whole movie up and then at the end go, I liked it. And, and then you haven't,
Well, I was kind of, when you told me what you were covering today, I was kind of curious how this worked with like Facebook and Instagram, where people add music to their stories or their reels. There's definitely been times when I've added music to, some reel I've made, and then I get a notification from Facebook that says your music may appear in some venues but not others.
Okay.
So I kind of read up on it just to see, and there was definitely some agreement that Facebook made with, I can't even remember the name of the company now, but
probably a record label or whatever.
It was,
Sony.
yeah.
I know Sony had a similar dispute with TikTok.
Yeah.
And
okay. So it's probably something like that. But but they, obviously Facebook licensed the songs that it makes available to you to add to your content. But they set out parameters of the limits of the time, the fact that what you're showing needs to be more about like the photos and the videos as opposed to the music that's behind it.
Yeah.
It's it's a gray area. It's literally case by case, and I think it's just one of those places in our law that you need to kind of tread lightly and err on the side of avoiding a copyright suit.
So that's kind of background on fair use and all this business. I'll tell you that Judge Beth Robinson in the Second Circuit did not buy the argument that this digitizing and systematized lending process constitutes fair use. In the opinion, she wrote that digitizing the books, quote, did not provide criticism, commentary, or information about the originals or alter the original books to add something new. Internet Archive's digital books serve the exact same purpose as the originals, making authors' works available to read. Later, she said that in copyright law, quote, not every instance will be clear-cut. This one is. To construe Internet Archive's use of the works as transformative would significantly narrow, if not entirely eviscerate, copyright owners' exclusive rights to prepare or not prepare derivative works, unquote. So the rule that for the fair use exception to the overall body of law that is copyrights did not apply here. The court had to find not only that transforming physical books to ebooks was not transformative in the way that commentary or criticism or anything else would be, but it also had to rule whether Internet Archives was profiting off the ebook lending, which it wasn't, and whether the publishers or authors were being harmed by this, which is up for debate. The court ruled in favor of the publishers on all of those issues, as I understand it. So what's interesting is the burden in this analysis, and it's for permanent injunction. Injunctive relief in particular has a lot of burden shifting back and forth, which I would have to go back and read before I told any of you. It's been so long since I've litigated that. But the long and short of it is there is burden shifting when you're getting into weird remedies like that, particularly like permanent injunctions. So, and by burden shifting, I mean it can become the defendant's burden to prove their innocence effectively on a certain element. So the burden in this analysis was on Internet Archive to prove that it had not harmed the publishers. And in arguing that point, they highlighted the surging profits of the publishers, of the 4 plaintiffs in this case, which is probably true. Nonetheless, the court rejected that, stating, quote, we agree with publishers' assessment of the market harm and are likewise convinced that unrestricted and widespread conduct of the sort engaged of by the defendant would result in substantially adverse impact to the potential market. And this is that fourth factor that we talked about earlier that's going to almost always go in favor of the copyright holder. Quote, the publishers have not provided empirical data to support this observation, and we routinely rely on such logical inferences where appropriate, unquote. And looking around some of the statements that were made by the folks that were invested in this, it seems as though the publishers like never turned over complete data on like the economics of how they were harmed. So there was a bit of a complaint of like discovery prejudice here. And we'll talk about that in a moment. But in any event, what are the effects of this ruling? More than 93% of public libraries participate in digital lending of some kind. Whether it is the controlled digital lending, like we talked about, the one-for-one way, or other ways, it's 93% of libraries are doing it. There were 62 libraries that were partnered directly with Internet Archives, so they're all in trouble now. If they can't do this controlled digital lending method, the one-for-one physical versus digital lending, as I understand it, their only option is to license the ebooks via the subscription model that most publishers do. And according to at least a lot of the briefing that was associated with these arguments, those licensing fees are getting like jacked up through the roof, as you can imagine. It's getting more and more expensive for libraries to do this.
Right. Well, and even you said that you could only download a work for a certain amount of time. So I would think, let's say it's, a year. They can increase the price of that book
At the end of the year.
Yeah.
Yep.
And I'm sure they're going to have some way of tracking how popular it is. Yeah.
100%.
And then they're going to jack up the price on the ones that are, more frequently checked out.
Yeah. Versus, if you want to put on like your, financial analyst hat here, like the amortized cost of a book that they bought 10 years ago spread out over, they buy the book is bought, they have the book, they can lend it out, versus this ongoing price hikes on the book, as it were, that can go up over time. Like the cost of lending a book theoretically would go down over time, right? You bought the book, the more times you lend it out, the more cost effective that purchase was. Here, it is the opposite.
Yeah.
There's an advocacy group called Public Knowledge that filed an amicus brief in support of Internet Archives and issued a statement afterwards, which is helpful to understanding this, which I'll quote from. Quote, controlled digital lending is a critical toolkit for libraries to reach their patrons in the digital age. With today's decision, the Second Circuit undermines those policy goals. We appreciate that the court set the record straight and clarified that a nonprofit's donate button does not magically render a use commercial in nature. However, the rest of the analysis falls short. The court asserts bafflingly that the Internet Archive is not entitled to statutory protections because it does not perform, quote, traditional functions of a library. It is unclear what the Second Circuit believes these traditional functions to be, if not lending books to the public. This is a case about the future of libraries as much as copyright law. On top of funding shortfalls and increasing censorship demands, libraries are being forced to repeatedly buy the same books over and over again due to publishing industry practices. This is what we're talking about. When libraries add print books to their collections, those books don't expire even when they are damaged, lost, or stolen. Libraries have the specific statutory right to create new copies of print books and other media because the preservation of knowledge and making works available to the public is both core to the mission of libraries and the purpose of copyright. With ebooks, libraries have fewer options. When libraries want to add ebooks to their collection, they can often only purchase a time-limited license, after which the books expire and have to be repurchased. The court recognizes that the result is regular renegotiation of ebook licenses that often come at a steeper price and for a shorter term than print copies of the same books, unquote. So, this...
So the court's acknowledging those issues, but ultimately it didn't sway
right.
the ruling.
I think the ruling boils down to not great for libraries, but copying... Look, scanning a copy of a book just feels like scanning a copy of a book, man. It feels like you're copying it. I don't know. I'm not an intellectual property lawyer. Please, intellectual property lawyers, if you're listening, do not come for me. But it feels like you're pirating it. Like, It just does, however you want to spin it. And unless there's specific statutory carve-outs, which it seems like there are here, this is what this statement is referencing, to which this website, apparently doesn't fall into.
I could see concerns from the copyright holders about the security of the online database.
Sure.
But it would seem like that, these whatever the 62 libraries that were using this company, I mean, that was they were doing their due diligence. Maybe they don't have the technological capabilities of that company. So as long as you have, a reputable company that's maintaining these databases, making sure that when somebody checks out an ebook, it can't be downloaded, shared, yada, yada, that would seem to at least address the issue of loss of revenue.
Yeah, I mean, the loss of revenue thing is interesting because I would put it this way. I think that publishers would, annihilate any and all exemptions or exceptions to copyright law if they could. You know, it's the fact that the fact that libraries are even allowed to lend books in the first place probably irritates them. Because they're like, you're getting your book for free, and we're not making any money off of that. Yeah. So like the financial motives are clear here. Like this, and I'm not even saying the publishers are like the bad guys. I'm just saying it would make sense for them to want to annihilate libraries as a concept. Yeah. I think it's interesting that the court says that Internet Archives does not perform traditional functions of a library because it is just lending books. Right? Mm-hmm. That's what it does, at least as far as I know. I will say this ruling makes me sad, just because I like libraries. And I have some more sad library facts for you all. According to a report in Publishers Weekly, which was originally published in 2021, there's been a 31% decline in public library building use between 2000 and 2018. That's 2018. That's pre-pandemic, so it's probably worse. Mm-hmm. The fall in public library building use was critical before the pandemic, and a continuing high level of use of digital materials, so ebooks, will make that worse, the report states. The report also acknowledges the contentious state of the digital library market, which the report suggests does not represent good value and may require a new strategic approach for the libraries. And most depressingly here, there's a discussion about the way that funds are allocated within the actual libraries themselves, because libraries often do classes, daycares, or things for
after-school programs.
All those things. Well, more of that money now will be sucked up into licensing these ebooks. So those things will also be diminished by this process, unless someone can figure it out. Going back to Publishers Weekly report, quote, the investment in digital materials appears to have taken away significant funds from that of physical materials, and the cost per circulation of digital material is 3.5 times that of physical material. In stark terms, in most libraries under current arrangements, it would be many times cheaper to give a patron the money to just buy an ebook rather than license a copy for the library.
Wow.
Yeah. So, libraries, bad shape.
Yeah.
And this ruling, this Second Circuit ruling here, does seem to put the kibosh on, one way that the kind of traditional library model could be adapted towards ebooks and things like that. Absent individual licensing agreements with each library, for which they have no bargaining power, right? Mm-hmm. Your local tax-funded library, can't go to HarperCollins and demand anything.
Right.
Now, I don't know if there was some type of collective, of all of the libraries that got to, like a union or something.
Or a statewide, maybe?
Yeah, something like that. And they can negotiate some type of deal, but why do the publishers even care? They don't want to deal with the libraries at all, probably.
Yeah.
So it's tough, folks.
Do you think they'll appeal?
I mean, who knows? One of the statements I read from the Internet Archives folks said they're evaluating whether they can appeal. And I mean, it seems like there are evidentiary and discovery issues, kind of like process violations that you could get into that would maybe give them another crack at it. But overall, I'm not particularly persuaded by the argument that, copying something isn't copying something.
Yeah,
They are copying it. Like,
right.
however you want to put it, if you can weave that into the narrow exceptions and argue public policy and try to get it under the fair use category. But like, you are starting from that bad fact of like, you're copying the book.
Yeah. And I mean, once again, I think it goes back to the lack of control, that the publishers have.
You mean once the book is in the hands of the library?
Yeah, and if they're going to allow, where are the checks and balances, I guess, of making sure that they actually follow that policy of a hard copy book is lent out and the digital one is pulled. A digital, is lent out, the hard copy is, because they really have only possession of one work.
I never really understood that's what was happening, but I use the Libby app, which is fantastic if you ever get a chance to do it for like audiobooks and stuff. And oftentimes I go on there to look for an audiobook and it's like, this title's not available. Like, what do you mean not available? It's not. How's it not available? Like, you have it. It's a digital. Yeah. But
okay, that makes sense.
I'm
checked out.
Yeah, I'm stupid for not understanding that they have a licensed amount of copies.
Yeah.
And they can only check out X amount of time, at a time. Right. So I would just be like, my app's broke. Can't get the book. But yeah, that makes sense now. But so if they're allowed to do that, they're paying a license fee.
They're paying, yeah.
Yeah, which is going to crush the libraries in the long run.
Right.
So it seems like it's just going to become more expensive to borrow ebooks and more expensive to borrow physical books. More expensive to maintain libraries, more expensive for them to put on programming, things like that. This is going to be a financial squeeze for them. And that's just sad, It's just not. I don't necessarily blame the publishers who they would say they are fighting for the rights of the creators, of the authors. Right. They will say that the authors are being harmed. And that's, I understand that. But it's just, it feels bad.
Yeah, it's unfortunate.
Well, the good news is no one reads books anyway, so so yeah, just listen to podcasts. Who cares?
Right.
All right. That's the show, everyone. Thanks for listening. As a reminder, there's nothing stopping you from going and supporting your local library. Doing the research for this show actually really made me want to go back to the library, which I haven't been in a long time, start taking my kid there. So we could reverse this dynamic on our own. But thanks for listening to this podcast in the meantime. And if you want to support our show, find us on Spotify, Apple Podcasts, YouTube, wherever you get your podcasts. Leave a review, give us 5 stars, help us out. And we'll talk to you in 2 weeks.